있습니다.
We have already formed a quorum. So we've got everybody in, and it is also time to start the meeting. So I call the meeting to order. And this is the meeting of the Subcommittee on Subsidiary Legislation made under the new Companies Ordinance. This is our third meeting, so please invite the team from the administration to join us. At the meeting held on the 27th of February, members completed the cross scrutiny of the company's directors' report regulation. In the light of members' concerns, the administration has submitted a paper, CB bracket 1667/12-13/02, to respond to the questions asked at the meeting on the 27th of February 2013. And then the Hong Kong Institute of Directors wrote to us on the 26th of February, and the administration has come back with a response which is contained in paper CB bracket 1 667/12-13/05, and the letter from the Institute of Directors can be found in paper bracket 04. Just tabled is a paper from the administration concerning proposed amendments to the Companies Directors Reports Regulation and Companies Summary Financial Reports Regulation. The paper has been given a number CB bracket 1 667/12-13/03. I would like to give the floor to the administration to walk us through the paper just tabled. Thank you, Mr. Chairman. Good morning, members. I would like to clarify with you. Would you like me to walk through the supplementary information paper? Yes, please. On the 27th of February, members are meeting, and in the light of the concerns raised, we have come back with a reply, and there is paper 667/12-13/02. Paragraphs 2 to 5 deal with the disclosure of registered name and liability status on websites, in particular in relation to the need to disclose the registered name and the liability status on websites. If I may set out the background, paragraph 2 talks about the existing position. Sections 4 and 5 of the regulation provided a company shall disclose the registered name and the status of limited liability on any website of the company. And there is also a definition in Section 2, bracket 3. This is in line with the UK requirements. In paragraph 3, to respond to members' questions, say, for example, if the website refers to more than one company. Now, what happens is that if the website refers to more than one company and all the related companies, if they have caused or authorized the website to appear, then all the companies' names should be disclosed. If there is a dedicated or thematic website for particular products, now we have to check whether the company has caused or authorized the website to appear. In that case, then the registered name has to be given. In paragraph 4, members raise a question about mobile applications, apps for short. Our view is that apps are regarded as a software, and the software itself is not being required to contain the name of the company. However, the relevant section of the regulation applies. In other words, if the apps would take the reader to the website of the company, or if the software is going to display document or instrument which is of a communication or transaction nature, then the registered name and status of limited liability have to be disclosed. This is because for communication documents or transaction instruments, whether they're in hard copy form, electronic form, or any other form, they will all be covered by the relevant regulation. Therefore, if you have an apps, but eventually the reader will be led to view the communication document or transaction instrument, then it will be caught by this regulation, and the registered name and the liability status of the company have to be disclosed. We understand that in the UK, Singapore, Australia, for the time being, they don't legislate about the need to make such disclosures in mobile applications. Mr. Mock talked about the domain name registration. We believe that it is different from what we are stipulating. We ask for the company's name to be disclosed in relation to the business of that company. But then for domain name, it may be another name in another company. And in the future, when we publicize the commencement of the ordinance, we'll refer to this point as well. Can you not pause here? Members, any questions? If not, then we can continue. Yes, please. Thank you, Mr. Chairman. Paragraph 6, that's about the equity-linked agreement. Last time, members raised a question about the definition. We provided some supplementary information on the spot. Here in paragraph 6, we say that the provision is a new one and the definition is also a new one. Therefore, the company's registry will consider issuing an external circular before commencement of the new CO to provide further guidance to the practitioners and the public. Paragraph 7 is about a point in Companies Directors Report regulation. Members referred to the concern about the resignation on the part of a director. In relation to the relevant section, we are going to make an amendment. Therefore, in the paper tabled before you today, we are going to propose certain amendments. Maybe I can come back to this point when we deal with that paper. Thank you. Members, any questions to follow up? If not, Mr. Yu, would you like to walk us through another paper? Yes, Mr. Chairman. As you have referred to a moment ago, last week, the Hong Kong Institute of Directors provided a paper to members setting out some of the views concerning the 5 pieces of regulations. We found that the Hong Kong Institute of Directors had no objection to the majority of the provisions contained in the subsidiary legislation. We have come back with this paper, CB bracket 1667/12-13/05, in order to set out our replies. First of all, companies, words and expressions in company names order. Well, last time we completed the cross-by-cross scrutiny of that particular order. For the words or expressions in that order, as we pointed out in the first meeting, there was an internal consultation. We believe that certain words like mass transit, underground railway, and municipal do not have to be come under restriction, and so we are not going to propose any amendments. Companies Directors Report Regulation. The Hong Kong Institute of Directors said that should there be an arrangement which would enable a director to acquire benefits by means of acquisition of debentures, the Institute would like to reinstate the existing requirements. If benefits can be acquired by a director by means of acquisition of debentures, some members raised a similar proposal at your meetings. We took into account members' views as well as the view of the Hong Kong Institute of Directors. We are prepared to propose an amendment, namely Section 3 of the regulation, so that the effect will be such that if the arrangement is to enable a director of the company to acquire benefits by means of acquisition of debentures, it has to be set out in the director's report as well. So this is in line with the existing legislation. But then for dividends, we propose that there is a need for disclosure, but then the Institute of Directors have noted that there's no need to disclose if exemption is given in relation to reporting. As we took into account the views of the industry. In fact, companies are already disclosing such information, so we do not propose to have any relaxation. So we will maintain the existing requirement under the CO, that is, the dividends-related disclosure will still be required.
Lastly, on summary financial reports, in paragraph 5, the Institute of Directors have a default position where if they have not indicated their inclination, then the printed company could be issued to a director. So they have asked whether the default position for receiving a summary financial report could be supplied through electronic means. Well, under the new CO, there is a arrangement for such a default position, and at the current stage we feel that we should retain the hard copy form. The principal legislation already deals with that, so we do not propose any amendment. Regarding the potential members, they have expressed some concern, and we have pointed out that it's not a regulation, the consultation of opinion can be made with potential members regarding the summary financial report. That's an enabling provision. So it's a very wide definition, and there should not be problems. In fact, in the principal legislation, there's already a definition for potential members, and we need to comply with the relevant sections. Lastly, the notes to financial statements, if we do not need to disclose that, and in the director's report, not all the financial report content will be included. We will just focus on the director's interests, director's benefits to be disclosed in the director's report. So under the current company ordinance, it's already being enforced. So we will just deal with director's benefits that need to be disclosed, and that will only be reported in the summary financial reports. Do members have any questions? So we have gone through this document and there are no questions. Mr. Yu, can you continue? We have just tabled a document 667/1213-03 on directors' reports and summary financial reports, where we have made some amendment proposals. Now, I suggest that we will deal with the directors' report regulations because we've already concluded clause-by-clause scrutiny. Regarding summary financial reports, in clause-by-clause, we could then put forward our proposals. Regarding director report regulation amendments, well, first of all, on resignation of a director, under Section 8 of the current regulation, if the director has resigned because of disagreement with the board of directors, then they need to make disclosure. Actually, there are two considerations. Since this is a new requirement and our aim is to enhance transparency of the company's operations, and the relevant regulations will not apply to companies that provide summary reports. We don't want to have huge compliance costs. And in paragraph 2, we provided some statistics where Hong Kong has more than 1 million companies, and we are aware some companies have more than 100 directors. In 2012, according to the registrar, there were 78,000 cases of director resignation, and there were over 8,000 cases belonging to public companies. Public companies do not have any exemption regarding reporting, so in the 8,000 cases, they might need to, they would be affected by director resignation disclosure rules. So, taking account of members' views regarding disagreement of directors with the board, and they feel that it's too restrained, then members can consider our proposal. That is, we can expand the scope of the regulation, where the director who has resigned, and if it's related to affairs of the company, then a disclosure needs to be made. We have attempted in the Section 8 of Directors Report Regulations for members' consideration. And on the last occasion, members asked, when will the regulation take effect? When does the director have to announce his resignation? The members felt that there should be a written resignation. So we also make a proposal, amendment proposal, where the director who resigns needs to provide a written submission, and the company has to receive this resignation notice to comply with the regulation. To put it simply, Section 8, where a director has resigned and he has provided that resignation in writing and the company has received the resignation, they have to consider whether the resignation is related to business affairs. Then the company has to disclose that in the director's report, and it is just a summary. It's not because they're concealing major facts, but there might be difficulty in disclosing the whole affair. Some information might not be relevant, and so on. So we propose that a summary would be sufficient. So the company just needs to provide a summary, and if members have questions, then of course they can inquire through different channels. So that is our proposed amendment on Section 8, and members can decide whether they need to expand the scope. Do members have any questions? Mr. Sin Zhonggai. This disclosure is a good example. I feel it's an improvement, but this type of disclosure, a lot of people resign for health reasons. If there are other reasons, then would that lead to misrepresentation, and would that be a breach of criminal law? Mr. Yu? First of all, the regulation deals with disclosure in directors' reports for resignation reasons, and these reasons are provided in writing by the resigning director to the company. And if for some reason, if the company needs to comply with the law, and it's hard for them to determine what are real and what are bona fide reasons and what are not. So the company's responsibility is to take these written resignation reasons. If it's related to business affairs, they need to provide a summary. If the company cannot comply with this summary report, then they do not comply with the new relevant regulations in the Company Ordinance. and there are penalties. Do you understand? Do you follow? Well, does it have any measurable effect that you need to disclose? Well, if they're not breaking law if they disclose false information. It's not false. The resigning director has to provide a written reason. While the director would only be aware of whether the reasons are valid. I don't agree with you saying that it's false information. The resigning director provides written reasons for resignation. While hearsay from the rumor mill cannot be included in the summary report. Am I correct, Mr. Yu? The chairman is correct. We have considered if the director is in disagreement with the board of directors and a typical way of displaying displeasure or disagreeing with the board of directors is through resignation. So the company or the director should provide the written reasons, and the company has to disclose that in the summary director's report. That is our requirement. I'd like to follow up this question. In private companies, these matters do not come to light, but in listed companies where directors resign, they have health reasons for resigning. So the real reason for resigning, is it really disclosed? We don't know. In his letter, he just says he resigns for health, for personal reasons. But in a lot of times, there might be disagreement, but they don't want to disclose that. So the simplest way is to say, for health or private reasons, they want to leave the company. But ultimately, we don't know what their reason for leaving the company is. Mr. Yu? The director has disagreement over the company's management or operations, but in the resignation letter, the reason is just for private reasons. So how should the director report deal with that? Thank you, Chairman. Director resignation, there could be a multiple variety of reasons, but the company can only the company is only aware of the written resignation reasons. We need a compliance procedure, and we can only rely on the director's written reasons. If they only mention private or health reasons, then the company, and if it's a private matter, they don't need to disclose. So it's up to the resigning director to make a decision to write as much as they want in the resignation letter. In 8.1a, there might be some room. It says disagreement with the board of directors of the company. So the disagreement, the director and the board of directors, have they made a resolution? And the director, they have direct disagreement, and the company is only required to disclose, because in actual operations, if the director Mr. Kwong, I'm sorry to interrupt. The government's paper, they have the new version. You're now referring to some old material. So the disagreement, let me inform you. Does he have the tabled version?
166
The number of the paper is CB bracket 1667/12-13 bracket 03. Can somebody cite the page reference for me? Yes, I see it. I'm sorry about that. So the reason for resignation so it is no longer with what was required in the past. So it's up to that director to decide as to whether the reason is to be disclosed. Is that right? Instead of just stating the disagreement. Well, we've changed the drafting for 1D due to reasons related to the affairs of the company. So it may not have to do with disagreement. As long as it has anything to do with the matters of the company, then disclosure is needed. If it is for health reason, then it has got nothing to do with the matter of the business. Company matter. That would also include the operations of subsidiary undertaking. Is that right? Well, it is quite broad in terms of the affairs of the company. So I think a holding company will be affected by the affairs of the company, which is a subsidiary undertaking. I think you need to make it clear because sometimes a large company actually operates via the subsidiary undertakings. So I hope it won't become a loophole because I'm afraid someone would argue that strictly speaking it is not affairs of the company. Mr. Chairman, if we are to spell out the specific circumstances, then we may not be exhaustive. We may cover some but not all. So it will be difficult to spell out the specifics. For us, affairs of the company, our understanding is that there are already previous cases, precedent cases, telling us what's meant by affairs of the company. I think we can cover the case referred to by Mr. Kwok. That is, if the subsidiary undertaking is to affect the parent company or the holding company. So a more general drafting should be fine. If I may pick up Dennis Kwok's point, what about if I'm a director of a subsidiary undertaking? I have queries with the policies of the parent company, and so I resign. Does it have to be disclosed? So I'm a director of a subsidiary company. I have problems with the policies of the holding company, parent company. So if I'm a director of parent company having queries about the work of a subsidiary, you say it is covered. I think you need to be less restrictive. Otherwise, when it comes to enforcement, there may be a problem and it will be too rigid. Yes, I do agree with you, Mr. Chairman. For a director to resign, there may be different kinds of reasons, and there are numerous of them. And we believe that the current drafting is broad enough. Now, you say that if a director of a subsidiary is not happy with the policy of the parent company, well, depending on the circumstances, if the policies of the parent company will have an influence on the subsidiary legislation, then it should be caught by such a drafting. Yes, our legal advisor would like to say something. Thank you, Mr. Chairman. In the light of members' questions, well, for the paper tabled, certain amendments are being proposed, and I think they would like to add a new definition. We have only got the English version, which is about the specified undertaking. Now, if we want to be more specific about the description of matters of the company, or the affairs of the company. Now the administration is talking about the affairs of the company. Maybe the government can consider affairs of a specified undertaking of the company. Then perhaps we can then resolve the queries in the mind of members. So for members' reference. Mr. Sin Chung Kai, Mr. Chairman, I'm still concerned about the question of criminal liability. Now the company has to disclose the reason given in a written letter from the director. Now for the company to reflect truly the reason in the summary, that would be fine. But then owing to certain objective circumstances, a health reason or personal reason will be given in the resignation, for the resignation. But then the director may go around and give another reason, which is supposed to be the true reason. If there is a difference between the reason given as well as the so-called real reason behind, will there be a problem? If the reason given in the written resignation is different from the true reason. You talk about criminal liability. Is it criminal liability on the director's part or on the part of the company? Now the company would, on the basis of the written resignation of the director, discloses the reason. And then, in fact, the director gives an incorrect reason to the company, and that would be the reason to be disclosed. Will the director be liable at all? Mr. Yu. Well, the CO itself does not say that there would be a criminal liability about the director's resignation. It is up to the director to resign. He personally knows for what reason he is resigning. Can we prove that the reason given in writing is not the correct one? I doubt very much. But currently, as the law stands, there isn't anything governing the reasons for resignation. Mr. James Toh. Mr. Chairman, I welcome the amendment because this is in line with what I have been talking about, but it has aborted my efforts. I've spent a few days to try to come up with a draft amendment. But still, I'm grateful to the administration. But then it is still regarded as a summary. Over the past few days, I tried to draft my amendment. There's one thing that worries me. If it is only a summary, of course, at the end of the day, if it is found that the reason given may run for 10 pages, and then if the summary is not a true reflection, then it means that the company has failed to discharge the requirement under H2. Because the summary has to be a true, reasonable and objective account of the reasons given. If at the end of the day it is not regarded as a bona fide or a genuine summary, then the company will be taken to court and then there will be some matching. Therefore, there will be some restrictions. The company cannot really go astray. But then, on the other hand, a director may think that his written reasons are better than any summary to be prepared by the company. Well, for the past few days, I was dwelling on this point. If the director states his reason in the text, say for example, if it is within the length of 1 page, then can we say that there shouldn't be any more summaries and the full text should be given? In this way, the director's choice of words will be reproduced. But of course, if the director is to come up with 100 pages, then we have to strike a balance. Otherwise, the director's report will just contain the reasons for resignation, and it will be rather like in the form of a book. So can we not adopt this approach? That is, had it been just running for 1 page or 2 pages, then the whole thing should be reproduced instead of coming up with a summary. This is to prevent one thing, that is, I'm still worried that the summary is just too general about the reason. Perhaps to expect the director to lodge a complaint, to argue that the reasons given are not, the summary given is not a true account. Instead of having such arguments, if the written reason is very short, then simply allow it to be reproduced, and then there is no need to worry about having been altered. Mr. Yiu, I would like to thank Mr. James Toh for this proposal. Of course, we only heard it today. As to whether in reality it will be facilitating the company, well, a director gives reasons to resign. Do we limit it by the number of words or the number of pages? Perhaps the number of words, said Mr. James Toh. Well, we confine it to affairs of the company. But what if in the page or two, first of all, he talks about poor health, and then he talks about matters of the company or affairs of the company. So there can be different kinds of scenarios. So it's better to adopt what we have proposed, a true account which is reasonable, which is which is objective. Should there be arguments, I think it has to be taken to the court. If a director succinctly puts down his reason in a sentence or two, and if it has to do with the affairs of the company, well, I just can't see why the company would not simply reproduce it in the so-called summary. But then, of course, there may be different variations, so it's better not to restrict it by number of words or number of pages. But of course, we are still open to your proposals. On the face of it, you may find it our proposal is very brief, but then it is a simple one and easy to enforce. Mr. Kwok, I think for the proposal made by the LA, that is to talk about specified undertakings, I think it's a very good idea. Some company directors may say that this may not be related to affairs of the company. It may be about something else. So he may adopt a narrow view. This is not affairs of the company, and then there will be no disclosure. So the LA has made a very good point. And then for H1B2, Mr. James Toh was worried about the summary. But I just wonder whether we can simply add something here. Must contain an objective and fair summary of the reasons so as to impose a standard. That is, there is a certain standard expected and required of the company. So that should there be a court case, you talk about summary, then you can summarize it in any way. Now, if we add the qualifiers fair and objective, then it will be easier to tell. Mr. Yiu, 2 points here. Affairs of the company, and whether we can further expand it to say specified undertakings. I think after all, we're talking about the director's report of a company. A director may resign over certain reasons. Now, specified undertakings would cover parent company, subsidiary undertakings, and sister companies. If, say, for example, as a result of his disagreement with the business of a sister company, a director may want to resign. It may have nothing to do with the related company, but still he chooses to resign. But do we really want the reason to be given? Sometimes it may be related. Then our drafting already catches that. But then it may not have anything to do with that particular company, but it has to do with the parent company or sister company or subsidiary undertaking. If it has got no clear relationship with the affairs of the company, do we still want it to be disclosed? And in fact, the number of directors resigning exceeds 8,000 cases. for listed companies and over 70,000 cases as the total number. So if we are to expand it further, I hope members will consider whether we are able to achieve a balance. Because if we simply talk about specified undertakings, then something obviously not related to the affairs of the company will still have to be disclosed in the report. For the time being, we don't think that is appropriate. For the summary, I think standards for the summary, I think it's up to members to comment. We are supposed to get reasonable summaries, but do we have to be explicit about the standards, and what sort of standards should we be talking about? It's up to members.
Do we have a definition for summary? No. Next we have Mr. Leung Kai-chung. Yes, I want to follow up on 812B. 812, the summary. I think a specific way would be to rely on the registrar. Could you provide a practice guideline? This is something new. So you ask the industry or the auditors to look at director's report. You need to provide some examples, a practice guideline. I think that's necessary. In the last meeting, I mentioned the equity-linked agreement, and now this reasons for resignation is also a new requirement. Could you provide some guidelines and examples? The company directors will refer to the registrar circulars. There might be some exceptional cases, and they would ask the company registrar for some guidelines. So I think having some guidelines and examples is very important. Mr. Yu, the company registrar, before the implementation of the new CO, will provide some promotion. They will provide guidelines to assist companies in complying with the company ordinance. These guidelines and promotional material is not just limited to equity-linked arrangements. It will depend on the need. I will follow up with the company registrar to see how we can assist new companies. I don't need you to do APIs and such, but we need to be specific. We need some pamphlets and technical issues. For technical issues, I hope you can be aware, and you need to provide us with some guidelines. I think Mr. Leung is concerned as an auditor serving a company. They need to know how to proceed. Otherwise, how can they serve their clients? How can they be accountable to the government? So from their perspective, they are very concerned about this issue. It's not about public awareness. The industry is concerned about their auditing services. Do we have Mr. Chen Galop? Kwok Wing Hung suggested in 8.2, referring to the summary, if he wanted to add fair, reasonable requirements. Yes, of course, we want the resigning director to have full safeguard and disclosure. But if you want the disclosure to be fair and reasonable, then would the company also want to state their case? So when you talk about fair and objective, would that lead to questions? That is, the company would also want to respond, to explain the resignation and some background information. Otherwise, it would just be one-sided. It would not be fair and objective. If we were to include the terms fair and objective. Mr. Yu? This is the legal requirement. The company has to comply. If the company wishes to tell their story, our rules do not prohibit the company from responding. But we allow the company to make a choice. We don't want to write it in the law. So the director report will become a debating ground. Chairman, I'm aware that this addition wishes to enhance transparency, so people outside can understand why the director is resigning. But I don't see how the summary reflects your intention, your purported intention. Because as members said, you don't have guidelines, you don't have anything. I can write down anything I want without any method to verify the veracity. Now, if other shareholders or directors, if they are aware of what's happening, this intention is not reflected in this arrangement. Mr. Yu? Thank you, Chairman. Well, if you compare the company ordinance, they don't have these requirements. So if a director resigns, and even if they have provided a full set of reasons highlighting problems in the company's operations, the company has no obligation to disclose that. And these might be very important to shareholders. So in this regard, requiring the resigning director to provide a summary in the director report, we feel that helps shareholders. And in our guidelines, we will follow up with the company registrar how, but at the same time, the disclosure is not the end of the incident. They have just disclosed the reasons. If the shareholders have questions, they would at least be aware of the matter and could follow up with the company or take other appropriate action. So there should be some assistance to the shareholders. I'm aware you have good intentions, but the law has to be effective. Any other questions? Let me summarize. Will you take up the advice of our legal advisor and make some amendments? Would you provide some CSAs? Our concern is that if you make amendments to specified undertakings, then it would include reasons not relevant to the company, and the scope would be too wide. The director report should just be limited to affairs of the business or business affairs of the company. Are members satisfied with this arrangement? I think the administration should reconsider. I think you can expect people to take a narrow definition. What is affairs of the company? Then our concern will be, this is exactly what our concern is. You should include business affairs of subsidiaries, parent company, holding company, and so on. But I'll allow you to do the drafting. Yes, we'll consider that. I think the administration have heard Mr. Kwok's views. Any other questions? Okay, then I'd like... Yes, Chairman. We've dealt with director resignation. In director report, we also have other proposed amendments. In paragraphs 5, 6, and 7, that deals with debentures. In dealing with the Institute of Directors, we mentioned that they want to reinstate the existing arrangements where directors, if they receive benefits through company debenture, it should be disclosed in the director report. We are aware that in this bill committee, members had made similar suggestions. So since the company ordinance has such an arrangement, we would like to amend Section 3 to reinstate to the current company ordinance arrangement. So whether a director of the company acquires benefits by means of acquisition or of shares or any other body corporate, they need to disclose that. So if there are summary financial reports, they are exempted. In Section 3, since we made this amendment, it deals with the arrangement of receiving debentures. So based on similar reasons, in 5A, Section 5A, the additional Section 5A, we have arrangements for company debenture disclosure. So to make it in line with our amendment, we want to include 5A, where if the company issues debentures, they have to disclose in the director report. So that is Section 3 and Section 5A amendment. Do members have any questions? I recall that some of our members had made some suggestions. Plus, the Institute of Directors do not object. Mr. Leung Kai-chang. The debentures in 2B, it includes all arrangements, including derivative instruments and rights. So it's the scope is quite wide. Is that correct? Section 3 is a wide definition. Any arrangement, it's not limited. Any arrangement where the director is allowed to receive benefits through debentures is included. So whatever arrangement is included. Well, I would like to reiterate one point. This type of disclosure needs guidelines. So you have to mention when will the right be exercised and the amount and so on. The users need guidelines. For example, share options disclosure. The company registrar. You have a lot of work set aside. Well, the amended Section 3 and existing CO is the same. So we believe compliance should not be a problem because they're already doing so. So can we provide further assistance, or we need to liaise with the industry? My understanding, we're now reverting back to the company ordinance, though there's no change. If they don't provide CSAs, then we will be dealing with new material. I understand the industry's concerns. Any other questions? Mr. Yu? Paragraph 8. Towards the end of the last meeting, somebody mentioned Chinese text of Section 9. We said that we are reinstating Section 470. The legal advisor was aware that the wording, the Chinese wording and the wording in Section 470, there is some discrepancy. Now we have reviewed the relevant sections, even though we updated the wording, the legal effect, there's no difference in legal effect between Section 470. But taking on board members' views to prevent misunderstanding in readers, in the future Chinese text version, we will make an amendment to make the reading in line with Section 470, but we need to make it briefer. Section 470, whether the wording will be further simplified. So I think it would be made clear. Please continue. In paragraphs 9, 10, 11, 12, according to the Company Ordinance, in 129D3J, if there is a contract that is relevant to the company affairs and the directors have interests, they have a material interest, then they need to disclose that in the director's report. Our original view was that in the financial report, the loans have some disclosure requirements, and for material interests would have to be included in the notes of the financial report for reference. But recently, after liaising with the accounting industry, the material interest, they want having that in the footnotes of the financial report. They feel that there are operational difficulties, especially if the information, the signing of these contracts are not the reporting company, but let's say the subsidiaries and so on. They feel these type of companies, the auditors might not grasp the information. So if you require the notes, the information in the notes, then there are some operational difficulties. So we suggest that under the new CO, we suggest the material interest information separated into two parts. On one hand, we have contractual information,
and entered into by the reporting company, then this disclosure will be made in the notes to the financial statements, and this will be prescribed in companies' disclosure of interest belonging to directors rules to be made. As to the transactions, arrangements, and contracts involving material interests entered into by specified undertakings, the disclosure will be the director's report. So the scope will be the same. In the future, instead of just in director's report, the company's dealings will be in the notes to the financial statement. For specified undertakings in the director's report. So we need to add Section 10 to companies' directors' reports rules or regulation. On the face of it, you may find that it is quite a long provision, but in fact we are just restating what disclosure is already required. So we believe that it won't have a lot of impact on the companies. So we've come up with this new addition. Members, any questions? Yes, LA. As to the proposed amendment to Section 10, if I may just clarify a point for members' reference. For Section 3, the amendment is such that directors of public companies will be regarded having a material interest. In Section 6, again, it is said that if a director, upon consideration, does not regard the interest as material, then it will not be regarded as material. So I want to know whether we are following subsection 6 when we explain or interpret subsection 3. So will subsection 6 be the basis for the explanation of subsection 3? Well, for subsection 3, the main legal effect is that for public companies, the scope of disclosure will not be confined to the directors themselves, but entities related to directors, say for example, family members and children. And this is in line with the disclosure requirements under Part 11 of the new CO. So this is different from the position under the existing CO. But then the new CO has already expanded the scope of disclosure concerning the associates of the or related persons of directors. So we have to expand the scope here accordingly. For subsection 6, for a particular transaction, arrangement, or contract, and whether the director has material interest, it is up to directors, the board of directors, to come to a decision. If the board of the director doesn't agree that it is a material interest, then disclosure is not required. This requirement is the same as the existing CO, so at the end of the day, it will be the directors' board that will be making a decision. Sorry, speaker is off mic. Does it mean that despite what we have got in subsection 3, a director may be regarded as having a material interest, but then under subsection 6, if the board doesn't agree that it is a material interest, there is still no need to disclose because it is not caught by subsection 3. Is that right, Mr. Yu? Allow me to clarify one more time. For subsection 3, as to what we are proposing, the purpose is to talk about the scope of disclosure. For public company, we are extending it to connected entities. For subsection 1, it talks about the need to disclose. So connected entity under subsection 3, the director himself under subsection 1, if the board of directors believe that it is not a material interest, then there's no need for disclosure. So the decision being made by the board of directors is the same as what we have got now. Yes, Mr. Leung. If I may explain it further to the LA, the way I see it is that for subsection 6, it is going to affect subsection 1 and subsection 3 because the board of directors will be deciding on whether there is a material interest or not. So subsection 6 has more impact than just subsection 3. It will also have a bearing on subsection 1 as to whether the interest is material, because in both sections it talks about material. So the responsibility doesn't lie with the director who has an interest to disclose, but rather the board of directors. If I may ask the Bureau this question, say for example, we may have a large group, then the disclosure will be in relation to that company, and then it will be in the notes to the financial statement. But what about other group members? In the director's report of other group members, the disclosure may have to be repeated if it is a material interest. Say, for example, that group may have 30 group members. If there is a material interest, then in his own company, this is disclosed in the notes to the financial statement, but the same has to be reflected in the director's report in the remaining 29 companies in the group. Have I got it right? Well, it depends on whether the director is also a director of other companies in the group. If a company has a contract with another company so that a director has material interest, then disclosure is needed. So if it is that company that is signing the contract, then it has to be disclosed in the notes to the financial statement. As to whether the directors' reports of other companies have to make the disclosure, it depends on whether they have the common director. If this is a common director, then according to the relevant rule, then this is a connected entity and disclosure is needed. If he is not the director of another company, then this director benefits from this reporting company transaction, but it has got nothing to do with another group member. And so the director's report of that group member does not need to make a disclosure. So do I understand it in this way? Say, for example, I'm in a holding company, and then under the holding company, there are some subsidiary undertakings. There are also further subsidiaries under the subsidiaries. I also sit on their boards. If there is anything related to me, according to this line of responsibility, all of them will have to report on my material interest. So if you are a director at different levels, does it mean that irrespective at which level of the hierarchy that I have a point, then I still have to make sure that all the reports throughout the hierarchy would need to make a disclosure? Well, it has to do with the affairs of the company. So if there's an arrangement that affects the entire group, all the companies of the group will be affected in a material way, then you need to disclose. If it affects a particular level or particular tier only, while others don't. McKenna?
The significance is in relation to the reporting company's affairs. So that is the trigger for the reporting. So depending on whether it materially affects the company that is reporting's affairs, or if it's significant in relation to that company, that's the trigger. I think that's what Mr. Yu's saying, yes.
Thank you.
Are there other questions? Let's continue. Mr. Chairman, I think I have finished with the introduction about the company's directors' report regulation. If members haven't got other questions, we can move on to the company's summary financial reports regulation. We are proposing amendments in 2 places, so I will walk you through that part of the paper when we come to it. All right, let's start the cross scrutiny of the relevant subsidiary legislation. There are 11 of them, and I think they are, first of all, the enabling provision is the same, and then for interpretation, I think I'll come to the definitions when that term appears. Section 3, forms and contents of summary financial report. So it gives you an idea as to what is to be contained. Basically, we are restating the existing CO. Say, for example, for 3A, it talks about the statement of financial position, statement of comprehensive income. 3B, if the company is a holding company, consolidated statement of financial position and consolidated statement of comprehensive income. For Subparagraphs C and D, we have taken into account the views of the accounting sector. Other than the comprehensive income, they have also got a separate statement. So since they have this sort of arrangement in subparagraph C and D, if they have a separate consolidated income statement, then the same information has to be included in the SFR as well. E1, that's about the information in the director's report, same as the existing CO. E2, for the disclosure regulation. I think this is the point we talked about a moment ago, and that's about material interests. Even as of now, the CO says that material interests have to be given in the SFR. Here, what we are proposing is that there should be an amendment, because for companies to provide information in the SFR in relation to the directors, first of all, material interests. Second, fees paid for the director's service. And thirdly, loans or quasi-loans between the director and the company. According to the existing CO, all of them would have to be disclosed as well. But then for E2, we have only dealt with the first part. And then for section 5, that's about the third point, that is about the loans. So unlike the existing CO, we do not include the payment for director's service.
Our proposed amendment is found in document 667/121303 Annex C, where 3E2, we do not limit them to these material interests. So all notes to the financial statements for the financial year as prescribed by the disclosure regulation have to be made. So that will be the document to be presented to the Legislative Council, the Company Ordinance regulation. So we don't have to separate the information. We can have in E2, where it is contained in the notes. So a simple expression can deal with that. Okay. Please continue. Section 4 deals with form and contents of summary financial report. We need to disclose the financial report. Important auditors' opinions have to be included, and there are some important disclosure, some important opinions. For example, whether a auditor has reservations, or does the audit report fairly and objectively reflect the company's operations, whether the company has sufficient financial information for the auditor to conduct their report, and whether the summary financial report and the complete financial report, do they have any discrepancy? Now, besides reiterating this requirement, we also have some new requirements. For example, if the auditor discovers that the director report and the financial report have any conflict, the auditor's opinion has to be included in the report. And if the auditor feels that the company has not conducted disclosure regarding director remuneration and benefits, they have to. The objective is to have the summary financial report reflect the auditor's opinions. So that is the requirement of Section 4. Legal advisor. In Section 4.5, we have a wording in Chinese and English for members' reference. In 5A, the English reads, whether the report is consistent with the reporting documents, and the Chinese says 是否互相抵觸. So in Chinese, if we say 互相抵觸, we mean whether it is consistent. So members can decide whether that is an appropriate Chinese-English reading. Mr. Yu? I'll have the law draftsman colleagues deal with that. Thank you. We feel 互相抵觸 should be amended to 相符. So, legal advisor, is there any problem? No. Okay, we accept that. Mr. Leung Gai-chung. Thank you, Chairman. In 4.4, auditor's report for financial year of a company contains a statement in Roman 1 and Roman 2. It says that if the accounting records have not been kept or the financial statements are not in agreement, then the summary financial report has to reflect that. But I feel that in subsection 4, in Company Ordinance section 408, it requires the auditors to have criminal liability. So in order to remind auditors of the criminal liability, whether the opinion is positive or negative, I would like a requirement to have that requirement listed, because if you don't have that requirement, they might make an omission. So could you check Roman 1 and 2 whether 408 needs to capture this, whether it's a positive or negative opinion? We require that to be disclosed in the summary financial report. Mr. Yu, what is your position? Mr. Leung is correct. The new CO 407 and the existing CO has a requirement where the auditor has an opinion. They need to disclose that in the auditor's report. The issue is whether it's a positive or negative opinion. Section 407 requires the auditor, if they have such an opinion, where there's inadequate records have not been kept, or whether their financial statements are not in agreement. So, in our summary financial report, if the auditor has stated such an opinion, the summary report needs to contain that disclosure. If the auditor does not makes an opinion, then they don't need to do so in the summary financial report. Well, I'd like to clarify. In the main auditor report, if the financial statements are in agreement and if records have been kept, does that have to be disclosed, even whether it's positive or negative? I just want to clarify. If it's positive, I recall that in the auditor's opinion, I have seen positive statements. Is that correct, Mr. Yu? In the auditor's work, I think Mr. Leung is familiar, but referring to section 407, if the auditor's opinion, if given the auditor's opinion, and if their adequate accounting records have not been kept and the company's financial statements are not in agreement, then the auditor needs to state such. You say that the records have not been kept, and but if they can take it one step further, but they can't shrug their duties. So if their records have not been kept or if there are disagreement, they need to disclose that in the summary report. Let's continue. Section 5, form and contents of summary financial report, other matters. In bracket 1, bracket 2, we mention if the company and the director has loans, quasi-loans, or other dealings, then they need to disclose that in the summary financial report. Now, the proposed amendment is that all disclosure requirements have to be disclosed. In 5.1.2, they are not required. We want to delete that. Next, 5.3, 4, and 5. These, the summary financial report, they need to state that the report only provides a summary, and company directors can seek the original version, and this has to be stated in a visible area. This was applied to listed companies in the past, and they had to be listed on displayed on the cover. Now we have relaxed it a little bit. It just has to be in a visible area, but it doesn't have to be on the cover of the report. As long as company directors or company members have access to the information, then it would be sufficient. That's a slight amendment. Please continue. Section 6. If the regulations can be met, then in articles of association, then the company can state the format of the summary financial report as long as they comply with the relevant law. Section 7. Notice of intent and notification. So the company can seek the opinion of members and potential members regarding the state of the financial year, whether they want a complete report, a summary report, and when they receive the report, do they want a hard copy or electronic version. The company can issue a notice of intent to the member, and Section 7 formalizes the procedure. The company needs to notify the member or potential member what choice they can have. They can receive the summary report or the general statement, and the reports they receive, they can choose a hard copy or electronic version, including information sent through the website. Now, the notification, if the member responds clearly, we also deal with a situation where the member does not respond. In the regulations, in 4C, we have a default position where if the member, they have not indicated their intent, or if it's after the deadline, then the company can issue a printed copy of the summary financial report. That's the default situation, and it's the same as the new CO. And Section 5, specified date. The principle is that the member needs to express intention to a company. It has to be 21 days prior to the specified date in order to comply with 3D and the 28-day requirement. And that is Section 7. Please continue. Legal advisor. Chairman, in Section 7.3, 3D. There's also a Chinese-English reading that for your consideration. In the English 7.3D, they refer to 28 days received by the company. In Chinese, it's 送达公司. So if we refer to bracket 4, we have a similar reading in Chinese, but it says 烧斗. Let's unify it to use the same Chinese wording. The English is the same, right? But the Chinese reads differently. Thank you, Chairman. Let me supplement. Actually, 送达, my intention was that I wanted to express the intention of receive, but why not use 烧斗? It's because in 3D, in 4A and B, it's the subject is different. It's not the company. It refers to the card or document. So in consideration of the context, 烧斗 is not so natural. So that's why where they read as card or document, I've used a separate Chinese expression. So I think it can still express the meaning of received. Perhaps legal advisor and members can deliberate over this arrangement. Do you accept that arrangement? Well, currently, my view is that we should unify it, make it uniform. And there are certain circumstances where you send material and where the company receives material, there could be a time difference.
取態係點？
I'm also a bit worried. 送底 may not mean that I just leave it at the doorstep of the company or leave it in the mailbox of the company. But then 收到 means that you have to acknowledge the receipt. When you talk about 收到 receive, if you refuse to receive it, I just slip it through the gap between the door and the floor. But then in Chinese 收到, you need to make sure that it has been received. It's the same like if you want to present a letter of protest. 收到 and 送底 would be different. James, I think your example is very good. But then one of your examples may not actually fall into this category. Say, for example, you go up to the company, you see a receptionist, you present it to her, but for a reason unknown to us, maybe I don't look handsome, he just show me the door and then she doesn't receive it. But it is not arguable. If the court accepts what I say is true, then it is not arguable. However, there is a scenario in which a worry may arise. You leave it in the mailbox, the letterbox, but then somebody steals the letter from the letterbox and he never receives it. But of course, if we go to the extreme cases, yes, indeed, there is a slight difference. Ms. Check, would you consider this? So it's a matter of where you draw the line. I think it's better to use 送底. In Chinese, I think you should render it into 送底 rather than 收到. You mean 收到? Yes. I did consider deliver and receive may be different. For 3C, in the case of delivery, in Chinese it is 送交. So between 送底 and 送交, I try to make it I try to distinguish between receiving it and delivering it. All right. If there aren't any questions, let's continue. Mr. Yu. Thank you, Mr. Chairman. Section 8, this is to supplement Section 7. Notifications sent by companies, and then the member may give a reply. That's in Section 7. Section 8, if somebody has already given notification or there is no reply and so the default comes into play, then Section 8 says that the member or potential member may give notice of cancellation or revocation, choosing another format. So the intent can be changed, and then the changed position will apply in the financial year. For revocation, it depends on when the company is to send out the financial statement or summary financial report. If 28 days, if there are still 28 days, then there will be sufficient time for the company to comply with the intention. No questions? Section 9 is a simple one. So a company may, in the notification, include other information if found necessary. So if more information may be provided in the notification, the company may do so. No questions? Then Section 10. In the notification sent out by the company to the member, they have to attach a card or document for reply mail so as to allow the member to indicate his intention. And the related one is Section 11. If there is an address in Hong Kong, that is basically if the member is within Hong Kong, then the company has to pay for the postage so that the member doesn't have to affix a stamp and can still send back the card or the document. This is to facilitate the member. However, if the member doesn't give an address in Hong Kong, so the company doesn't have to pay for the postage in advance. Okay, no questions? Then explanatory note, simply an explanation. I think it should be fine. So we are finished with the 5 pieces of subsidiary legislation in the first stage. If I may consult your views, both members and the administration. Advisor, do you have anything to add? We haven't got the Chinese version of the amendments. I think you need time, so I have not insisted on getting that today. But then the next time you come back, you need to give us the bilingual version. Yes, this is the draft CSA. We'll try to see if further adjustments are needed, and then we will come back with the Chinese version. We haven't got many members left, just Mr. Kwok and Mr. Chen. Do we need another meeting? Or when the paper is ready, there is the CSA paper. When it is ready, we just leave it in the hands of the legal advisor, and then she will be the gatekeeper, and then we will have a circular. Or do you want to wait for the final version in both languages? If you choose the latter approach, the timing will be tighter. So do you want a meeting, or do you want to leave it in the hands of the lawyers so that they can tidy up the loose ends in the light of our discussion? In particular, for today's meeting, both in terms of policies and in terms of the drafting, there have been some suggestions. Do you want an additional meeting? Your advice, please. Mr. Chairman, there are quite a number of questions asked, though not too many of them. Some of them are quite crucial. So to play safe, I think it's better to have an additional meeting. Yes, I agree. I do understand that it will be rather tight. Perhaps a very short meeting will suffice, as we have only got 3 members left. So I think perhaps we need to enlist the help of the Secretariat. So perhaps the administration has to expedite. We have the scrutiny period being extended until the 27th of March. However, for me to report back to the House it should be the 15th of March. We've only got 9 days left, as we are on the 6th of March today, for notice to be given to move amendments the 20th of March. In other words, if we want another meeting, we need to get everything ready before the 15th of March. I suggest that we have it on the 11th of March at 10:45. Yes, I think I'm available. So it is you whether you can finish the job in 5 days' time. So have overtime work. I will do my best. Don't just say you do your best. Well, we have the draft with us. There aren't too many changes proposed today, so for the English version it will be fine. For the Chinese version, we believe that we should be able to complete it. Ms. Check, probably you have got a greater workload. I'll try my best to tie in with your work. All right, 11th of March, 10:45 to 12:45. The Secretariat has to count whether we can have a quorum on that day. But I'm sure they are very efficient. Yes, we'll try to provide the information to you ASAP. So you need to do it ASAP. It will be after the final meeting, then we have to talk about the content of the report to the HC. What about the second batch? I think we can deal with that at the final meeting. That's it for today's meeting. Thank you.